People often assume that when someone represents themselves in court, going pro se, they lose because a judge thinks they're foolish, or simply because they aren't a lawyer. But intelligence has very little to do with it. Self-represented cases rarely fail on the arguments themselves. They collapse because the person steps onto a procedural trapdoor they didn't know was there. Taking on that burden on purpose requires a specific motivation. It's about radical self-reliance. It is the peace of mind that comes from carrying your own weight, knowing the case is yours and yours alone. Keeping that level of autonomy comes with a strict trade. You give up the passenger seat. If the wrong paper gets filed or a deadline slips, there is no attorney to point a finger at. Stepping into a courtroom alone is an exercise in extreme accountability. It is the end of the passenger seat, a choice to carry your own weight and own the final result. To see where self-representation makes sense, we can look at the legal system as a tiered building. The lowest floors are the most forgiving. Small claims and simple, form-driven civil disputes are actually built for non-lawyers to navigate safely. But as you move up to cases involving heavy discovery, expert witnesses, or irreversible stakes, like a criminal trial or an appeal, the walls get higher and the margin for error disappears. Understanding this architecture of risk is the mandatory first step. If you wander into one of those high-stakes rooms without representation, the complexity of the venue itself will defeat you. Strip away the specific laws, and almost every lawsuit runs on the exact same procedural spine. This rigid sequence applies equally to seasoned attorneys and first-time litigants. The first trapdoor is the wrong court. Federal courts, for example, have limited jurisdiction. If you take a standard state dispute to a federal judge, the case stops dead before anyone even looks at the facts. If you survive filing, you hit the service requirement. You have to physically deliver the complaint according to a highly specific set of rules, and then officially file the proof that you did it perfectly. Get the method wrong, and the case vanishes. In this way, the legal system acts as a mechanical filter. It is built to cleanly eject cases that fail basic procedural compliance early on. Once the other side is served, the clock starts. A missed response is the third trapdoor, and the countdown runs at completely different speeds depending on your state and the exact type of filing. Missing an answer deadline can easily result in a default judgment against you without a single hearing. Even if you reach a verdict, the most dangerous timeline of all waits at the end. Post-judgment appeal windows offer absolute zero margin for error. A day late is entirely too late. Surviving this gauntlet requires mastering one very unglamorous tool, a single master deadline sheet, filled out the second a clock begins. The quietest risk in navigating these rules is emotional. The stress of litigation often pushes people to ramble, overclaim, and lean on their personal anger instead of hard evidence. The most effective defense against this is to write 2 drafts. Let yourself feel the anger in the first draft. Put every grievance on the page. Then, burn it. The version you actually file to the court must follow a rigid, emotionless formula. You state the issue, cite the exact rule, point to a specific page in the record, and ask for one distinct piece of relief. Judges often decide entire motions without a hearing. Cases are won with perfectly tabbed binders and clear proof charts, not with theatrical speeches in the courtroom. True legal advocacy for someone representing themselves is dry, precise, and completely stripped of grievance. Taking extreme accountability for your case does not mean you have to fight the entire system in total isolation. You can use a hybrid model. You keep your hands firmly on the wheel, managing the daily procedural spine yourself. Then you hire a lawyer for exactly 1 hour to review your work right before you cross the trapdoors. Targeted legal review is a tool of executive management. It allows you to respect the expertise of the system while maintaining absolute authority over your own case. When a self-represented person finally stands in the courtroom, they shouldn't look like they are trying to imitate an attorney. They look highly organized, procedurally sound, and steady. They reach that point because they did the quiet work. They picked the correct venue, they defeated the countdown clocks, and they constructed an airtight evidentiary record the judge could actually use. By surviving the technicalities and maintaining total control over the process, the final judgment, win or lose, belongs entirely to them. There is no one else to blame.